Yes. My dear lordship indulged themselves matters. But my lord was granted leave to do urgent. But it was listed. There are urgent because listed, the bottom, not top. So it should be top 10. Thereafter it has gone to my lord another bench. But then it has not been reached. Unfortunate and it is unfortunate it was not reached. Your lordship kindly take
Another bench means by the order of the Honorable Chief Justice, it was sent to the other bench. Okay. এটিকে আবার এসছে। What you do is, I request you to mention on Tuesday. Since Friday and Monday is not the mentioning day, so come on Tuesday, we'll definitely. May I be permitted to mention not today, on Tuesday? Lordship, one thing is that this matter was granted bail, interim bail till 27, Lordship, and her ladyship was directed to list this matter immediately after Puja vacation till 27 October. The interim bail exists, Lordship. I'm praying that this matter be listed at the top on Monday, Lordship, or else my bail will be this matter will be infructuous, Lordship. Second page, second paragraph, Lordship. Till 27, interim bail exists. And the last page, Lordship, our ladyship directed that this matter be listed after the vacation, after the court reopens after the vacation. Where is this thing? Till 27th, yes.
Tuesday I shall come, my lord, and call lordship session, but it is urgent. Petitioners are without salary from 2021.
But Tuesday come.
It was not hard. Our lordship was pleased to direct the matter will come up for hearing, reopening of the day. I have annexed the order, my lord. Next page, my lord, and mark some portion in. It was not hard.
তাহলে 27 তারিখের লিস্ট হবে, আজকে তো হবে না। 27.
My lord, may I permit it to be
Both the
made?
matters, two matters are there.
Same thing, my lord. Kindly,
দেখি
my lord, can you do two matters? And mark.
আর দেখি
My lord, may I permit it to be mentioned, my lord? My lord, it was in the vacation bench, my lord. Application for bail, my lord.
Similar prayer, my lord, I am praying for inclusion. It was never heard, my lord, despite I have already served to the opposite party.
Application for
এটার নোটিস পিরিয়ড ভিডিও আছে, দেখি ওই পেজটা দেখি।
I have served the opposite party, they have received it also. I have the receipt also.
কোন সেকশনে মামলা? This arises out of POCSO.
POCSO, my lord. Bail of
Yes.
POCSO. It was never heard, it was running in the list. I have served, evidence service is also ready.
ওটাকে দিয়ে দাও, এদেরকে ওদের দিয়ে দাও।
The matter to appear on 27th.
First you change the mentioning slip.
I will keep them.
faithfully.
না দাও, call the
I am her petition, my lord. Petition expire, my lord.
I have received.
Now I heard that petition expire, my lord. Kindly leave to file a substitution petition, my lord.
May I submit the report, my lord?
There was a direction to serve.
Instruction এসছে আপনার কাছে?
আমার কাছে কি আসবে?
The advocate for the petitioner,
আমি
Mr.
ওরা
Suen,
টেলিফোন করে
the advocate for the petitioner submits that petitioner has.
জানছে না। মনে হচ্ছে কিছু হয়েছে।
There is only one petitioner.
My lord, one petitioner, my lord.
Submits that the petitioner has expired on which date?
My lord, I heard that now, my lord.
Submits that he has received information that the petitioner has expired. He seeks accommodation to take appropriate steps. Let the matter go out of list with liberty to mention. After you,
May I submit?
My lord, adjourn for 2 weeks, my lord.
Report, my lord.
after you file the application, get the necessary information. You
As if.
mention.
Wait.
At present,
Advocate.
it's out of list.
If it is out of list, he will take steps and mention.
Very good.
My lord, item number 2, Miss Apurupa বিশ্বাস is an online, my lord.
Where is your track consignment report?
Lordship, affidavit of service.
Who is for the state? Priya Ghoshal, on number 8 and 9. 8 to 9. Where is the service? Service has been affected. Service has been affected.
Lordship, service affidavit.
Where is that? Not been affected. Not been affected on 3rd September. 6th September. Service has not been affected as well. Yes. Nothing on point.
For the petitioner, my lord.
There was a direction to serve upon respond number 3. You have served, but the track consignment does not show that it has been served upon respond number 3.
My lord.
Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service has not been affected on respond number 3. Pradhan Keodatala Gram Panchayat. Accordingly, learned advocate for the petitioner is directed to serve absence upon respond number 3 through registered speed post with acknowledgement due and file affidavit of service to that effect on the returnable date. Respond number 8 and 9 is not represented. অন্যদিন পরে। Please this matter on 7th November. Take this back. Affidavit of service টা দিয়েছে না?
Yes, my lord.
সার্ভিসটা নিন। Yes.
Item number 3.
For the petition. But this is a bit of service. I have served everybody, but respond number 5, 6, and 7, they have refused, madam. Okay. But the matter relates to construction of a boundary wall. In this regard, my lord, I have made a representation before the authority concerned on 15th of May 2025. That is at Annexure P2, my lord. This is a Rayati property. The property belongs to me, my lord. And I made a representation before the authority concerned, but authority concerned did not take any steps. That is why I have come before your lordships.
Yes.
So kindly
Therefore-
consider this representation, my lord.
Which field is there? There is a civil dispute, what I find from the petition itself, you know. So kindly see paragraph 3 at page 4.
Page 12 and 13. This is Now, kindly have a look, page 12 and 13. 12, the Ganesh Raut is the owner of the property. And I am the? Yes. I am the wife of Ganesh Raut. So, my lord, kindly have a look, my lord. Khotiyan number
Pradhan do if you
1782.
opposite party respondents are obstructing in your making construction of the boundary wall, it is a civil court which you have to approach.
No, my lord, because I am the owner of the property. I am the Rayati in favor of me. I am the Rayati.
Somebody is disputing your right over the property. Now your case
So-
is that you are trying to build a boundary wall around your property,
Yes, my lord.
but the respondents are obstructing to that construction.
What is
What
their
will
right?
Pradhan do?
That is why I have come.
What will the Pradhan do in this?
The Pradhan actually, my lord, Pradhan should intervene in the matter
Why? Why you will intervene?
because, my lord,
This is your private property, you will give a boundary. If there is obstruction, there is a civil dispute, go to the civil court, get an injunction and construct the boundary wall. Awesome. Affidavit service filed on behalf of the petitioner is taken on record. By the present writ petition,
but, my lord, kindly for a moment, my lord, that civil suit was there, my lord. That was withdrawn. I withdrawn the civil suit
why?
because
What was the contents in the civil court?
since I filed this application before your lordships, I have filed this application before lordships. Naturally, the civil dispute will come. That is why I withdraw this, my
Where is
lord.
that?
Eh?
Where is the order?
My
Where is
lord,
the copy of the plain?
But that was not written. My lord, kindly, my lord, give me liberty to file a supplementary affidavit. Then I shall provide that copy, my lord, that I have withdrawn this.
Then again, this being a dispute of civil in nature, only to sustain a writ petition, you withdraw the civil case.
Because
The ground of withdrawing it.
automatically they will say that the civil suit is pending. But situation is this, kindly, I am the right. Property belongs to me.
Your relief is with the civil court. If there is a dispute in
Yes, ma'am.
peaceful enjoyment of your property, if a riot is being obstructed by some trespasser or outsider in
Outside.
enjoyment of his property,
Yes.
where is his relief? You tell me, where is his relief? His relief is before the civil court. You have rightly filed a civil suit. Why did you withdraw to sustain a writ petition?
Because the legals here, they are not disturbing. They are the outsider. They are
That is
stranger.
what I am saying. They are the outsider. They have no right title interest over the property of yours, your property. You have a relief before the civil court. You withdraw the civil court to sustain a writ petition.
But I withdraw
Japan.
this since this matter is pending before.
That is the order of the civil court.
The injunction was there. Order আছে? But kindly give me liberty to file a supplementary affidavit. I provide that order. Next week,
Then
my
it
lord.
will be kept pending.
Kindly,
Nothing will come out of
injunction was there.
Injunction was there, you withdraw the. Who advised?
Injunction was there, my lord. Nothing remains with this matter, my lord.
But I withdraw this application since,
The right goes.
but kindly give me liberty to file a supplementary petition. I should provide that
Even if you
injunction
file,
order,
nothing
my
will
lord.
change. No circumstances will change.
আপনি সিম্পাটি নিয়ে লোয়ার কোর্ট চলে যান ওখানে, নাহলে ওখানে ওটাও ফাইল করতে পারবেন না।
I dispose of the writ petition.
The writ petition is
And
not
also-
maintainable, my lord, because my lord, there is no allegation against the state respondent, my lord.
করা হচ্ছে।
There is no infringement of any
আমাদের
personal right, my lord.
মানে হ্যাঁ তো সেই ইনজাংশন অর্ডারটা আমি দেখবো But kindly give me liberty, my lord. I provide that injunction order, my lord.
Then there is no whisper in the writ petition about the suit itself, my lord. What my learned friend is saying, my lord.
Evidence service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities to consider her representation
ইনজাংশন ছিল তো
dated 15th May 2025 and 3rd June 2025. Para. The petitioner contends that she is the absolute owner. Sorry.
12 and 13, my lord. It indicates that I am the absolute owner of the property.
Landed property measuring 23 decimals within Dag number 1548 and 1547, jail number 143, block Khanakul 2. আরে খতিয়ান নম্বরটা আগে দেবে না? খতিয়ান number 1782, Mouja Polaspai, belong to her deceased husband. The private respondents are trying to trespass into the property of the petitioner and are constantly threatening the petitioner. The petitioner approached the local Gram Panchayat to arrange for a boundary wall in and around her property for peaceful enjoyment of the same. However, since no steps have been taken, the petitioner is compelled to constrained to file the present writ petition. Mr. Vansol, an advocate, affidavit of service বলেছে? Advocate for the petitioner submits that the petitioner is the absolute owner of the property in question. The private respondents have no right title interest over the property. Sorry, private is having no right title. Having no right title is constantly threatening the petitioner. So, the petitioner approached the local Gram Panchayat for erecting a boundary wall for peaceful enjoyment of the property. He seeks that the matter be relegated to the Pradhan of local Gram Panchayat for consideration of the representations of the petitioner. Para. On the contrary, Mr. Swenso, learned advocate appearing for the state, submit that the dispute is civil in nature. And as the petition is not maintained. Wrong. Wrong. None appears on behalf of the private responding despite service. The contention as culls out from the writ petition is squarely with regard to obstruction being caused by private respondent in construction of a boundary wall by the petitioner. The dispute is precisely civil in nature. Accordingly, the writ petition is not maintainable. Hence, the writ petition is dismissed. It being number WPA 13078 of 2025 is dismissed. However, it is left open to the petitioner to approach the jurisdictional civil court for appropriate relief. Image the blood আসছে appears on behalf of the petitioner, nor in the affidavit of service filed. For instance, just the matter is adjourned. Please this matter to look after 2 weeks under the same heading.
Then I,
Milord, I am for the private respondent.
I'm paying for
My lord has heard the matter in details. Submission of the writ petition has already been completed. And I have already started my submission. Milord, the fact has already determined in the other writ petition. And thereafter still the private respondent make this present writ petition, suppressing the material fact of the case the other writ petition has already decided. In the meantime, a civil suit is pending. And my lord has asked me to show that document also regarding that I am producing this document before your lordship. Your lordship, kindly come to the page 3. This is the civil
So
suit.
private respondent or state?
My lord,
Private respondent.
I am for, no, in the civil suit, I am for the plaintiff, and in the writ petition, I am for the private respondent.
Lord, I'm praying for a short passover.
Now, if your lordship kindly see,
My lord, the advocate on record is engaged in another court. My lord, he called me and asked me to pray for a short passover. Just a short passover, your lordship.
he had already concluded his submission also.
Eleven 45.
He promised.
my lord, in this matter, I am appearing on behalf of the petitioner, my lord.
My lord, Mr. Shantanu Chatterjee is appearing for the state in this matter. He is out of station, my lord. So I am praying for only for not today, my lord.
My lord, case is, my lord, unauthorized construction made by the private respondent, my lord. Against that matter, I filed my objection against before the matter Panchayat authority.
Your name? What is your name, sir?
My lord, my name is Mr. Sudipto Kumar Basu.
Deepak Kumar Basu.
I am not in the state panel, my lord. I am just his junior.
Advocate seeks accommodation on personal inconvenience of Mr.
Yes,
Who is
my,
your senior?
my lord, Mr. Shantanu Chatterjee. He is appearing for the state.
Chatterjee, open advocate for the state. Next Friday there again. No, 25 কবে নিচ্ছে? 25 গুলো কবে নিচ্ছে? Wednesday. Wednesday. When
Well, I filing my affidavit of service kept with the record, my lord.
service has been affected.
Service effective. The tab recorder also is there, my lord. I have checked tab, my lord, already service effective.
You have not sent to respond number 6 and 8, 6 and 9.
I have checked tab already, my lord. Your lordship, last occasion matter was moved before your lordship. Your lordship directed me check up the affidavit service. I have checked tab, my lord. Already service effective.
Corrected the receipt. Who has corrected this receipt? Corrected the receipt of Somedu.
Tag report is there.
The postal receipt. Who has corrected and incorporated name of Sahajan? Sahanaj?
The name of
Sahanaj? The notice was sent twice to Somedu. Now, one of the notices I find that it has been corrected, pen through, and made Sahanaj. Respond number 8. Give me that. Did you find it?
my lord.
Did you find what I am saying?
Well, I have already forwarded. Address is there, my lord. Already forwarding data is there.
দেখুন এইটা এই যে টিক দিলাম, এখানে কে করলো এটাকে? এই নামটা কে দিল? মানে নামটা কেটে দিয়ে টু পেনে কে লিখবে? তার কোনো ইনিশিয়াল নেই, পোস্টাল অথরিটি ওর লেখে।
আমরা কেন হাত দিব? Postal receipt already issued by the postal authority, my lord. We have not given any sign on the postal receipt.
Who has corrected it?
I have checked, I've already received the document, postal authority, my lord, reported that it has been already served, delivered,
ঠিক আছে। দেখুন,
already delivered.
civil service file on behalf of the petition is taken on record. Wednesday. Wednesday.
Well, when your lordship fixing the date?
29th Wednesday.
I'm for the respondent number 5 to 10, my lord. I'm led by Mr. Shomi Ganguly. I'm praying for not this week in this matter, my lord, as my senior counsel
I'm-
is out of the station.
I am appearing on behalf of the petitioner, my lord.
Motion for the state.
I have served upon all respondents. They have duly received it. I am submitting affidavit of service. Let it be kept with the record, my lord.
You are 5, 6 and
5 to 10, my lord. Jilla Parishad.
there are no private respondents.
No, my lord, there are no private respondents.
5 to 10. Affidavit of service filed on behalf of the petition is taken on record.
না না আমি বলেছি তার সঙ্গে এটা বলেছি
Miss so and so, learned advocate for respond number 5 to 10. 6. Accommodation on the personal inconvenience of who is the learned advocate? Who is the learned advocate?
Lordship, my senior counsel is out of the station as in
Who is what is his name?
Shomi Ganguly.
Somi Ganguly.
His father is in emergency, Lordship, that on this medical,
Represented.
I'm praying for not this week.
It is represented. Wednesday.
COVID.
Yes. But I am for the last occasion your lordship directed again served to respondent number private respondent, but not twice I have served. This is the two affidavit of
File
service.
affidavit of service.
This is for unauthorized construction without sanctioning plan. Whether my learned friend has taken a
Yes, my lord. I'm for the state, my lord. I am handing over the report. My lord, this construction is being carried out strictly in compliance to a sanctioned building plan. I'll take to your lordship.
give me a report, my lord. I will see. And
My lord, kindly see, everything is there. Permission for erection of structure and building.
Paragraph he has stated.
Yes, my lord.
Which paragraph he has stated?
My lord, may I read out a very detailed report has been given. My lord will kindly come to the page 3 of the report. During inquiry, I went through the available record of PS and found that on 18/5, the writ petitioner came to Daspur police station and submitted an application in this regard. Before the on-duty table officer, he lodged a general diary entry such and such as per endorsement number. It is further submitted that the allegations are mainly regarding a land dispute which is civil in nature, and they have stated, my lord, the copy of the prayer before the Pradhan Daspur 7/1 GP Daspur block number this is annexure B. My lord, they have constructed in accordance with the prayer. My lord, kindly come to the annexures.
Give me a copy so that
If my lord directs, I'll certainly give. My lord, will the report be given to the other side? Apni bolo na, I got a copy. A prayer was made to the Pradhan, Daspur. My lord, the Daspur Pradhan has given a detailed report. May I read out, my lord?
Which page?
My lord, it comes to annexure B of my report. With reference to that, I would like to inform you that Sayyid Abul Hassan, son of such and such, the allegation that one Sayyid Arshad Ali is making illegal and unauthorized construction of Pakka house over the disputed plot without obtaining any sanction plan under section 23 of the West Bengal Panchayat Act 1973, as well as not obtaining any no objection from his co-sharer. I pray before your good office for supplying necessary documents and information in respect of the below mentioned scheduled landed properties. Given the schedule, now comes the report, my lord. The very next page. Office of the Daspur 1 Gram Panchayat. আপনার গত এই 23/6/2025 তারিখে প্রদত্ত চিঠির প্রতিক্ষেপে আপনার অবগতির জন্য জানানো যাইতেছে যে সৈয়দ আরশাদ আলী পিতা সৈয়দ দানবীর মীর গ্রাম মামুদপুর পোস্ট দাসপুর জেলা সাচ উনি গত 8/6/2025 তারিখে বাড়ি নির্মাণ করার জন্য অনলাইন আবেদন করেন এবং দাসপুর 1 গ্রাম পঞ্চায়েত সাচ উপর বাড়ি নির্মাণ করার 23 তারিখে অনুমতি প্রদান করা হয়।
how can it be? No, this is the co-sharer property.
My lord, whatever
Without
maybe it's a civil
without
dispute.
objection
My learned friend should go to the civil court.
That is other thing.
Yes.
Give me a report.
I will certainly, if my lord directs, I'll certainly give.
I deal with
Yes.
every paragraph of it.
Then come to
Lordship.
annexure. After annexure A,
Annexure A.
then subsequent there is a report of BL LRO.
Lordship. As per owner of LR Khatian plot number Mauza says as per physical inquiry report submitted by concerned RI Sayyid Arshad Ali son of Sayyid Danur Mir of over the suit has been constructing a Pakka building over the suit plot.
Subsequent page, subsequent to the
Subsequent
annexure
page. Lordship.
A. As per available LR ROR, the owner of LR Khatian number 3924, it is the subject matter of this.
Lordship.
The owner is Sayyada Tumpa Begum.
Maybe it has not been changed, my lord. I have not, so far as the report is concerned.
So how come if the owner is Sayyada Tumpa Begum, how can the
My lord, it is the
permission be
petitioner's
granted?
contention. He is the owner. The writ petition source says he is not denying that. My lord,
How come permission is granted in favor of Sayyad Arshad? If Tumpa Begum is the owner,
my
then
lord,
how the
I have
permission
to
is
read out the lordship. My lord, the second paragraph of the report. I perused the entire petition where it is found that the writ petitioner submitted that he along with others are the owners of plot of land. White plot number 905, Khatian number such and such, jail number this. The writ petitioner also stated that one Sayyid Arshad Ali, son of this, such and such, making illegal and unauthorized construction of Pakka house over the disputed plot without obtaining any sanction plan under section 23 of the West Bengal Panchayat Act. as well as not obtaining no objection from his co-sharer, that it implies, my lord, that he is the owner? The writ petitioner himself says that he is one of the co-sharer. If he is not obtained any, if anything is there, he should go to a civil suit and file partition suit. How will
So
that?
copy of the report to him. And
I
also
will
file
supply a copy.
report by
Lordship.
way of affidavit by
Yes.
the block development officer.
Lordship.
Is the block development officer party?
My lord,
You is
Yes.
the party in this?
Am I right? Yes, yes. 6. Respond number 6.
State files inquiry of statement of facts along with annexures which is taken on record. Copy, sir. The petitioner in the present writ petition alleges of unauthorized construction by private respondent. Private respondents, they have been served.
But twice I have served. Only 2 has not been received. Your lordship directed again served. Lord, I am again served.
My lord, the very next page says there are 6 brothers who are the owners. My lord, the next page of the that out of the land 15 khatas, one Nausar Ali and his sons, 6 brothers are the joint owners. And the private respondent against whom the alleged illegal construction has been raised, he is also one of the joint owners. It is a version of the writ petitioner. And if that being the version of the writ petitioner, my lord, if he has any doubt, anything, whether he is constructing without taking objection, he should go to the civil court.
কি বলো? Affidavit of service filed behalf of the petition is taken on record. হ্যাঁ, ওর উপরে দিয়ে দিন affidavit of service. ওটার copy, sir. The petitioner alleges of unauthorized construction by private respondent number 4. No, by private respondents. Which private respondent is making construction? Which one?
Private respondent number
7,
8.
8. Over land comprised within plot number 905, Khotiar number 3924, Mauja, Mahmudpur, jail number 61, district Paschim, Medinipur. An advocate for the state submits that the construction has been undertaken by private respondent number 7 on the basis of sanctioned building plan. State is directed to furnish a report to block development officer respond number 6, block development Daspur, in the form of affidavit. Report in the form of affidavit within a period of 2 weeks, exception if any, we find within a period of 1 week thereafter, 3 weeks for normal ending under the heading returnable motion. First date bolun. Second date 25 September. আচ্ছা ঠিক আছে 2nd December.
2nd December, man.
Yes.
Lordship, grateful, man.
Item number 5,
My lord, I am appearing for the writ petitioner.
I appeal for the petitioner, my lord. Item number 5.
5 or 9?
5. 5.
Item number 9.
That's one. This matter was previously heard.
You know, subject to the leave of the court.
Panchayat, your lordship sanctioned the matter.
You
Panchayat
have concluded your submission also. I am continuing my submission. You please allow me.
Yes, what was your submission? Panchayat you have served?
Yes, yes.
No,
Panchayat
I am-
paid for time
My lord,
on the last occasion.
I am for the private respondent.
This is my lord,
In fact,
indicative service.
The last occasion, lead petitioner concluded his submission. And I have started my submission. The particular question arises, I then
May I restore my lord my submission?
make a submission as the matter is already is deciding by the civil court. In that event, can lead court exercise the jurisdiction? And accordingly, my lord has directed me to place the document also.
Here, my lord, my challenge is,
May
my
not
lord,
kindly see.
Panchayat passed an order of demolition,
Panchayat?
despite there being sanction plan.
Now,
my lord, in the civil court, several matters are pending.
not the
These
civil
are in other cause of action regarding encroachment he has filed, but I have also filed. This is civil matter. Now, my lord, with regard to this application, my lord, I have challenged the order passed by the Panchayat directing
Already,
my
my lord,
construction
there is a
to be
there is an
demolished.
injunction order. Injunction order is prevailing in the suit premises. Lordship, kindly see that my document I have placed.
My lord, injunction order with regard to the encroached portion is there. Now, my lord, with regard to my entire construction being declared illegal, my lord, I am before your lordship.
Yes.
Despite there being sanction plan. Order under challenge is at page 64, my lord, kindly see.
Page 64 arises in view of the coordinate bench, the writ and the other writ petition also filed. And under these circumstances, not that coordinate bench directed and ultimately Panchayat has passed the order. If your lordship kindly see the page, the
Page 65 is the operative portion.
65 the operative portion,
Yes.
lordship kindly see, এমতো অবস্থায় বিবাদী রথীন কুমার সমাদ্দারকে জানানো যাইতেছে যে আপনি পঞ্চায়েত নিয়ম লঙ্ঘন করিয়া ও অনুমোদিত প্ল্যান বহির্ভূত নির্মাণ কার্য করিয়াছেন, তাহা অদ্য আগামী 15 দিনের মধ্যে ভাঙ্গিয়া ফেলিবার জন্য নির্দেশ দেওয়া হইতেছে। অন্যথায় পঞ্চায়েত নিজ দায়িত্বে নির্মাণ কার্য আবার যথাযথ ব্যবস্থা গ্রহণ করিবে এবং অবৈধ নির্মাণ ভাঙিবার জন্য যে ব্যয় হইবে তাহা আপনার নিকট পঞ্চায়েত উদ্ধার করিতে পাইবে। Lordship, kindly see, this order has passed in view of the another writ petition filed by my client, the private writ petition. If your lordship kindly see the document which I have enclosed before your lordship. Lordship, kindly see the page 16, the other writ petition.
Yes.
And now, my lord, kindly sees the Panchayat, while passing the order, consider the sanction plan dated 14th of December 2021. That is ground source sanction plan. Now, my lord, on 28th of December 2024, I have already obtained, my lord, first floor sanction plan. And in terms of that sanction plan, I have constructed first floor. Page 54 is my first floor sanction plan. That has not been considered while passing the order.
Page 54.
Page 54.
You have not traced this particular.
Yes, I have placed. My lord, my written submission, my lord, I have what I have, my lord, submitted. My written submission, my lord, in the is that, my lord, page 59 onwards, where I have particularly stated that I have twin float sanction plan. In terms of that sanction plan, I have constructed my portion. Page, my lord, 59 onwards. Kindly see, 16th of March 2025, they have received plan permission, land character change certificate, everything. Annexed at P7. That is my written submission before my hearing, before passing the order.
Where in the submissions you have stated that on 2024 there was a subsequent sanction of the building with regard
Yes,
to the
yes.
first floor. Which place?
My lord, kindly sees page 62, my lord, in the there is no numbering in the paragraph.
Where? Nothing has been stated.
Panchayat buildings or within the own construction of it.
Not stated.
Question of encroachment is there, my lord. May I, madam? Specifically, my lord, it should be very candid before you lordship. Specifically, when this was sanctioned or not, that has not been written in the written submission. But my lord, in the received, my lord, copies, land permission was, my lord, submitted. And my lord, I have already submitted in this petition also.
Where?
Page 54 is the first floor. First floor construction, which was sanctioned on 28th of December 2024.
First floor.
Yes,
Where
that
the
is on page 54.
ground floor.
Ground floor is on, my lord, page 51.
Ground.
Now, my lord, they have considered the ground floor sanction plan. First floor sanction plan, they have not considered.
But in ground floor also there is a dispute.
Yes.
Ground floor, my lord, with regard to ground floor, my lord, there is no dispute. They have stated that I have, my lord, not left.
They have considered the ground floor and
Yes.
they say that there is illegality in that.
My lord, what is the report, my lord? I have not been served with the copy of the report. My lord, let the engineer, my lord, measure my plot. Let a specific report be submitted. Thereafter, let him take a decision.
Already measured.
No copy of the report was supplied to me. My property was measured. I have not been supplied with the copy.
But not disclosing the fact.
With regard to the civil code, my lord, to me, my lord, it is absolutely with regard to encroachment and has nothing to do with the writ petition. And in continuation with their submission, if the civil suit is pending, my lord, they have filed writ petition in which, my lord, they have,
Your civil injunction also dismissed. Your appeal also.
during pendency of civil suit,
The report of the Pradhan, the order passed says that notice has been served upon both the sides.
Is notice of
They have
hearing,
asked to
notice
remain
of hearing.
present on such and such date at 2:30 p.m. and Amin was sent to measure the land and it was found that there is a deviation.
But whether any deviation is there, there must be some measurement. That copy has not been served upon me. And my respectful submission is that, my lord, let both the sanction plan consider, let a, my lord, proper measurement be there and take a decision within a particular period.
Where is the order passed by this court in WPA 1612/22?
My lord, that order, my lord, I have annexed.
My lord, if your lordship kindly come to my notes.
Yes,
in
page
70.
56 in my petition. Page 56. That was a consideration order. Page 57 is the operative portion. Third paragraph from the top. The writ petition is accordingly disposed of by directing the respondent number 6, that is the Pradhan of Nosratpur Gram Panchayat, to consider and dispose of the writ petition made by the petition. Representation made by the petition. Strictly in accordance with law, after giving opportunity of hearing all necessary, including the petitioner at the earliest, but possibly within a period of 3 months from the date of communication of this order. The writ court has not gone into the merits of the case, but to my lord, subject to correction, my lord, writ petition, in the writ petition filed by themselves, the writ court did not go into the merit of the case, only directed to consider the representation and pass a reasoned order. And in the said writ petition, my lord, I did not, my lord, appear. It is true. Page 56 is there.
You also did not appear before the Pradhan,
Yes, Pradhan I have appeared. Before Pradhan I have appeared.
but you have not placed the sanction.
I have placed, but kindly see, my lord, page 59. What document received? They have stated land permission, land character change certificate. Both the document I have placed. Page 59. In the endorsement, it has written.
Land permission is the permission of 14 December 2021. That is also plan permission.
Yes, but 28 December 2024 is also there.
In writ petition, you have stated that subsequently it was sanctioned, first floor sanction.
Yes,
Which paragraph?
yes, I have annexed the document.
No, which paragraph you have stated
My lord.
that subsequently a plan was sanctioned?
My lord,
7.
7. P7.
Wait,
My lord, page paragraph 7. Moreover, my lord, subject to correction of your lordship, if I have any deviation, my entire building cannot be declared to be illegal.
That's to be demolished.
But if there is deviation, my lord, for the sake of argument, if I admit that if there is 3 feet deviation, let them say there is 3 feet deviation. And entire building should not be held to be illegal since I have my sanction plan.
What did he say?
If
They
the,
said entire building is illegal.
yes, if the statutory gap is not maintained, then what will be the phase? Civil court has made an observation.
Palace is the ordering portion, my lord. শুধু তা নয়, পঞ্চায়েত অনুসারে নির্দিষ্ট পরিমাণ জমি ছাড়িয়ে নির্মাণ কার্য করা তাহাও করা হয়নি। হাউ মাচ ডেভিয়েশন ইজ দেয়ার, দ্যাট ইজ নট ইট বিন
Yes,
রেকর্ডেড
It is recorded in the order sheet.
and is specified, sir.
করছি সাবমিশন দেখাবো হয়েছিল আমার হাতে খুলে যাচ্ছে।
Your client tried to overreach the order of the court
Yes.
because in 22, the order is passed in the writ petition with regard to your sanction of building plan with regard to the ground floor. Suppressing all these aspects, you apply for first floor. Since there is unauthorized construction on the first floor, you apply in 24. When there was a order passed by this court for consideration of the ground floor. And got it sanctioned.
Now,
Now you say that Pradhan has not considered the first floor. But the first floor was not before the court because that was not sanctioned at that point of time. But the construction was made.
now, my lord, I did not
No,
have
no,
the
no.
notice.
The construction
With
was
regard to
made.
their writ
You
petition.
apply in 24 knowing fully well that there is a order of this court to consider whether the ground floor is legal or illegal.
If there, my lord, my ground floor plan was sanctioned in 2021.
So why did you apply in 24?
2021 in my ground floor was sanctioned.
That was
Now, my
that
lord,
was considered by the
that
court.
writ petition I did
That
not
Pradhan
appear.
has right
Whether
to-
notice has been served or not, my lord, that also, my
One
lord, I
cannot
could,
consider your first floor
I
sanction.
did not have the knowledge.
You did not have the knowledge.
I did not appear
Court
even.
passed the order in 22 to
22,
consider whether the ground floor is legal or illegal. In the meantime, in 24, you make application for first floor. That is sanctioned and you say that Pradhan has not considered. Pradhan is not duty bound to consider your first floor because the direction is with regard to the ground floor.
if there is no sanction plan, my lord, my building can be declared to be illegal. Now, my lord, if my ground floor plan is there, my lord, if
It has
there
been
is
made
deviation,
consideration of the first
if I have not left, my lord, the statutory side portion, my lord, what portion, how much portion is there deviation, that should be specified in the order.
What prompted you to file an application in 24 for getting a sanction plan of the first floor? When you know that there is a direction
No,
of this
I
court,
did not have the knowledge. Did not have the knowledge. I did not appear in the writ petition even. Kindly see the order. I did not appear in the writ petition. It
Why?
was passed in their presence only. Even Panchayat did not appear. Kindly see the order.
service was effective.
But whether service was properly effected or not, my lord, that I could not found, my lord. I did not have the knowledge with regard to this order. This was a consideration of representation consideration order. Subsequently, when I received the notice of hearing by the Panchayat, I came to know about these facts.
The court bill has made an observation. The statutory gap at the ground floor has not yet maintained.
Pradhan,
Yes, your lordship kindly see.
Court below, my lord, civil court.
Civil court has made an observation. Lordship kindly see in page 13, while injunction order is granted, page 13.
একটা কপি যদি দেন।
এটা তো তোমাদের কাছে রয়েছে, তোমাদের কাছেই রয়েছে। এই কেস তো তোমরা কন্টেস্ট করেছো, তোমরা ফাইল করেছো, অ্যাপিল হেরে গেছো।
আমি জজ সাহেবকে যে পোর্শনটা দেখাচ্ছেন ওটা তো আমি দেখিনি।
তোমার থেকে চেয়ে নাও না তোমার ক্লায়েন্টের কাছে।
page number?
Lordship kindly see in page 13. In page 12 is the order dated order dated 28 April 2025, the second page. Therefore, in spite of such order and during pendency of the suit, defendant number 1 is making the construction of the commercial building without leaving the statutory gap of 3 foot, and as a result, the several crack has been formed, and hence the house of the plaintiff. Further, from the commission report, commission has also, it is the report of the commission. Commission also observed that it transfers to this court that the defendant number 1 did not allow the advocate commissioner to enter into the B schedule property, that is his property. He had lot of quality also.
If the civil court say that my construction is illegal,
পরিষ্কার করে বলে দিয়েছে
let the civil court execute the order.
illegal construction বলে declare করেছে তার
You are, the private respondent is taking recourse of two sides, two remedies
No.
in two forums.
আরে এটা তো তোমরাই কেস প্রথমে ফাইল করেছো, তারপর কাউন্টারে ফাইন্ডিং, ইউ কাম টু দ্য ফাইন্ডিং হচ্ছে statutory gap of 3 foot to be maintained. You have not whispered about the civil court in your writ petition.
So the suit is pending.
Yes,
Suit is pending.
Suit is pending.
Suit is pending.
Suit is pending.
Court observation, defendant is making construction upon B schedule property by violating the prescribed building rules and regulations.
আমার করা মামলা,
In-
আমার করা মামলা হলে আপনি তো ডিফেন্ডেন্ট।
না না তোমাদের এটা আমার
How many civil suits are pending?
yes,
How many?
Well, 3 cases are there.
my civil suit is
cases
pending.
are there.
Their civil
He's-
suit has already dismissed.
I have filed a
They
suit
also
for it.
preferred an
Enforcement-
appeal. Thorough. Preferred an appeal, that also dismissed. They did not take the steps, ultimately the appeal gone. Now this is the position.
Where is the paper?
Your Lordship, I have given this. If your Lordship kindly
Whether my
come,
lord appeal is dismissed or not,
Page
my lord, that I know. I don't have that instruction.
Lordship kindly come to the page 12.
Appeal কি dismissed for default হয়েছে নাকি?
No, page 12 is the injunction order.
Page 12 is the injunction.
No, where is the dismissal of the appeal?
And
Their suit?
their suit, my lord, that I have not annexed, probably. I do not know.
My lord, so far as my instruction, my lord,
Oh, they-
suit
They also filed that.
recovery
counter-
of enclosed portion. Recovery of enclosed portion.
that motion.
I think Lordship may have been. I think if your Lordship will kindly have a look at the earlier order passed in the earlier writ petition, while seeking direction upon the authority concerned to take step with regard to the unauthorized construction under the Act, Panchayat Act. Now, my lord, that writ petition, after having been disposed of, directing the authority concerned to take consideration of the Act itself, and also, my lord, the taking into consideration of the other fact that whether any plan sanctioned or not, if sanctioned, then whether there was a deviation or not. So these are the factors to be considered by the authority concerned. That while considering that, my lord, exercise, that the only thing, because now, so right of ownership, right of possession, right of, my lord, my lord, the acquirement of any other property, all these things, I think
that would not come in the stand of the way of exercising the power with regard to that, my lord, the whether the construction that has been made, that is according to law or not. The right of ownership, right of possession, other right, that is totally separate.
Yes.
So, my lord, kindly let him, my lord, the petitioner, he only has to establish that only thing. That yes, construction is according to law. That is. All other factors, my lord, that would not come in the way.
Yes.
They are subject to the leave of the court. I think what I have understood, my lord, today. Taking this view, the issue is that either the construction is lawful construction or unlawful construction. Panchayat has already declared upon verification, upon report, and it is the finding that the ground floor is an illegal one, and ultimately the Panchayat declared this is the building which has been constructed on the premises is a wholly illegal construction. The finding of that construction is that the construction, Panchayat directed the writ petitioner to demolish the building at your own cost, otherwise we will be compelled to demolish the building and we will recover the entire cost. That is the finding of the Panchayat. Lordship, kindly see in the writ petition at page 65 at the last portion.
Yes.
At last portion. And this has arises, a contempt as arises, not in contempt, Panchayat Pradhan also appeared. And this coordinate bench also imposed a cost of rupees 20,000 rupees fine. Impose a fine of 20,000 to the Panchayat Pradhan also.
Where is the road?
Lordship, kindly see. In my report, page 1, Lordship, kindly see.
In the content, my lord, I was not a party, so my lord, I don't have that instruction.
Page 1. The coordinate bench, para 3, order sheet. The court is unable to accept such explanation for delay in complying the court order. Hence, both the contemptors are directed to pay 20,000 each with the block development officer Purvashali by June 26th. And this order has been complied by the contemptor also. Ultimately, finding is that either the construction is a lawful construction or not.
No, this has to be, Mr. Sen, this has to be referred to the SDO.
Yes.
Matter has to be referred to the SDO by the Pradhan.
As an appellate.
Not appellate forum, as per section 23.
Yes.
Section 23.
As per section 23,
If it is found that
Yes.
the sanction finds that there is contravention,
Pradhan can only
refer the matter.
Yes.
Let
But
me
the
refer.
decision has to be taken by the SDO. Get
Affidavit of service
video
filed.
has also
Affidavit
called
filed.
for a hearing also.
SDO
SDO has also called for a hearing. Probably I can recollect.
Affidavits of filed on behalf of the petition is taken on record. By the present writ petition, by the present writ petition,
No, I beg to apologize for the
petitioner
my respectful submission.
seeks
Issue is that regarding the section 23, that can be referred to the particular authority. But the writ code, the finding of the writ code, writ jurisdiction, it has also observed that the construction which has made by the writ petitioner in the present writ petitioner,
No.
that is a completely illegal
No,
one.
court has not observed.
And court also finding.
Court
And
has not
accordingly,
observed. Panchayat Pradhan observed.
yes.
Court has not observed.
Now I am asking this question to myself. If the finding of the writ court comes into conclusion that the construction was an illegal, in that event, can this authority have the right and jurisdiction to decide the
Court
matter?
has not decided my illegality of construction. What are you saying?
Already rules of natural justice has decided.
What rules of natural justice
Yes,
court has decided?
Deciding the rules of 226 have decided.
Who decided?
Pradhan decided.
Question is
Read court has not observed even.
read court
By
finding.
the present writ petition, the petitioner seeks for setting aside of the order dated 4th June 2025 passed by the Pradhan Natratpur Gram Panchayat. The petitioner contends that the work of construction of the ground floor has been undertaken in terms of the permission granted by the local Gram Panchayat on 14th December 2021. Subsequent thereto, on 28th December 2024, permission was granted to construct the first floor. There is no such deviation from the sanctioned building plan. The Pradhan, who has passed the order? The Pradhan, by the impugned order, has not considered the plans that were sanctioned in favor of the petitioner. Talk further, no such measurement has been made. Being agreed by the impugned order, the petitioner has preferred the present writ petition. Mr. So and so learned advocate appearing for the petitioner submits that the impugned order is palpably illegal in view on the ground of non-consideration of the building plans is lagaben sanctioned in favor of the petitioner by the local Gram Panchayat. No such specific measurement has been undertaken. It is for setting aside of such order. On the contrary, Mr. So and so learned advocate appearing for private respondent number 7 and 8.
Milord,
7, 8 both.
7-8. 7-8 এর জন্য আপনি
7 and 8
হ্যাঁ
submits that the private respondents have filed civil suits in which the court, after considering the commissioner's report, came to a finding that requisite side space of 3 feet has not been left out by the petitioner. Moreover, upon notice, the inquiry was made by the local Gram Panchayat, wherein it was found that there has been deviation from the sanctioned building plan.
Milord, subject to the leave of the court, one prayer before your lordship. The present writ petition has filed at much later stage because they have already contested in the civil court.
সিভিল কোর্টের সেপারেট ইস্যু স্যার তো বললেন
Civil court case is started suit 285 of 2022 and this writ petition is 2025.
You know,
অর্ডার পাস অন 4th of June 2025
plan. Therefore, the Pradhan by the impugned order has rightly directed for demolition. Mr. HON'BLE Sen, Kumar Sen, no? learned additional advocate general appearing for the state submits that by the previous order passed in WPA 16120 of 2022, the Pradhan was directed to, where is that order page number? Pradhan was directed 56.
Is that my lord page number
Directed
56?
to consider whether there is violation of the plan sanction and then take necessary steps. The Pradhan has found out that the construction is illegal. Therefore, as per section 23, the matter should be referred to the subdivisional officer for further course of action. This is second round of litigation. In the earlier writ petition filed by private, both the private respondents filed the writ petition earlier.
My lord?
Both the private respondents filed the earlier writ petition.
Yes, yes.
Yes.
Filed by the private response 7 and 8, being WPA 16120 of 2022. Following direction was issued on 22nd August 2022. 57. Since the order was not complied, the private respondent filed a contempt application in which the rule was issued, being WP CRC number 57 of 2025. Thereafter, the impugned order has been passed by the local Gram Panchayat. Para. It is found from the impugned order that the order passed in the earlier writ petition is confined to the plan sanctioned on 14 December 2021. It is found from the impugned order of the Pradhan that notice was served to both the sides for causing inquiry, and an Amin. A Amin was appointed. Amin tana inverted comma. Amin was appointed to cause measurements. It is further observed that the construction work undertaken by the petitioner is not in accordance with the sanctioned building plan. Section 23(5) provides as hereunder. 5 again. 23(5). In view of the aforesaid provisions, since the permission granting authority, that is the local Gram Panchayat, has found that there has been contravention in the in making of the building, the permission granting authority is directed to refer the matter to the subdivisional officer for taking further action when, as per section 23(5) of the West Bengal Panchayat Act 1973, within a period of 2 weeks from date of communication of this. আচ্ছা ওখানে উপরে একটা করুন যে the order of the civil court also records order of the civil court dated 8 April 2025 placed before this court by the learned advocate for the private respondents also records that there is the construction has been undertaken without leaving statutory gap of 3 feet. Without leaving side space of 3 feet. ওপরে একটা জায়গা দেবেন। With the aforesaid observation, the writ petition stands disposed of.
My lord, SDO shall take further course of action. I mean, my lord, for further course of action regarding demolition. Now, my lord, if my lord by deviation is there, entire building cannot be held to be illegal, my lord.
He will consider. He will give you notice. He will consider.
My lord, kindly record that, my lord. The SDO will consider. Kindly record.
It has been recorded that he will consider in accordance with 23(5). He will give you a notice.
Yes, my lord.
Give you a hearing. Thereafter, place your case before the SDO.
My lord, my lord. My lord.
तो कोई आते हैं हाँ
Germany ঘুরে যা
Yes, my lord, this is my writ petition, my lord.
My lord, Mr. Torunjyoti Tiwari is appearing for respondent number 7. My lord, due to mistake of his clerk, my lord, he forgot to bring his main brief, my lord. I'm praying for
My lord, the
today,
brief
my
is available on the website, Sharthak, my lord, website. My lord, it can be downloaded right now and he can make the appropriate submission. My lord, in earlier occasion, they have filed the report in form of affidavit, and my lord, this is my affidavit in reply to that report. And my lord, I want to press my.
They have filed a report.
Yes, they have filed the report on 15th September 2025.
Needs to file a report. On which date they have filed?
And I have also already filed just now, my lord, the affidavit of exception.
The report.
lord. We have already filed our report, my
My lord, report has already been filed. That is, my lord, that will be appearing from the order sheet, I think.
My lord.
Yes, my lord, the report is here.
Yeah.
I have already filed the affidavit of exception and it was served on. Copy serve করেছিস? It was served on 17th September. So, my lord, the matter, I am pressing my writ petition, my lord. First, I am coming to their affidavit. The writ petition was filed, the decision-making procedure of the particular NIT, my lord, and the contention of the writ petitioner was that, my lord, the work order was issued upon the incumbent without having the technical qualification.
So your technical bid was accepted.
My technical bid was accepted and it is to be revealed from their report, my lord. I was also financially qualified. But my contention is that they said that the particular respondent number 8, the alleged successful bidder, and the petitioner is jointly become the L1.
Very weird.
My lord, kindly have a look to their report, my lord, first. My lord, got the report?
Yes.
I am the respondent number 8. My lord, I, Shukanta Das, such and such. I am the respondent number 8. Pradhan of Faridpur Gram Panchayat. But it will be appearing from the writ petition. The respondent number 8 is the alleged successful bidder. This is the misrepresentation. The copy of the above referred writ petition has been served upon myself and I have gone through the same and have perfectly understood and purport and content thereof.
I asked my learned advocate to appear in such and such. I have prepared a report such and such. Milord, then, Milord, the report is annexed herewith
My
as
internet
Art 1.
starts, my lord. There is a typographical error in my report. In the first paragraph of the report, inadvertently it is stated that I am the respondent number 8, comma, Pradhan. Pradhan is respondent number 7. That is inadvertent error.
Yes, Milord, that can be overlooked, Milord.
Yes.
Milord, the report is, they have filed the report of the Pradhan at annexed being annexed R1 at page 3. Milord, then, my lord, your lordship got the particular page, Milord. Then, Milord, paragraph 1. On 7th March 20, NIT was issued, being tender number such and such for installation of building, drinking, or subsequent financial bid was open. Petitioner and respondent number 8 become the lowest bidder jointly out of the 8 participants. So, admittedly, my technical bid and financial bid was accepted. And thereafter, on 8th April, a meeting was called at Faridpur Gram Panchayat in terms of the notice dated 3rd April 2025. In that notice, it was categorically stated there will be a table bid at 2:30 p.m. for selecting the successful bidder. Notice was received by the parties. Yes, my client has received the notice. On 8th April 2025, petitioner was present but refused to participate in the table bid, and accordingly, respondent number 8 was declared L1. Now, my lord, kindly come to the paragraph number 7. Yes, the NIT dated such and such clearly speaks about the eligibility criteria. As per the same, both the petitioner and respondent number 8 qualified. I am disputing this statement, my lord. I say the respondent number 8 did not have and presently does not have the technical qualification. So the technical bid of the respondent number 8 should have been rejected, and there is no question of allowing the financial bid. The petitioner did not participate in the table bid. Milord, they have not annexed any notification saying that table bid is mandatory after there is a tie. First of all, they have to show that the respondent number 8 was technically qualified, but none of the minutes, only minutes has been given, but nothing has been given that the particular respondent number 8 is was technically qualified. In the writ petition from page 60 to 83, the document regarding the credential of the respondent number 8, those are the technical credential, Milord. I am coming to the NIT, to my writ petition and the NIT first, and thereafter to the report again. Then, Milord, the annexed page P1 and page 14 is the NIT, Milord, of the writ petition. P1, page 14. This is installation of the building and drinking water ATM near Moitari Hanuman Mandir at such and such. Estimated work is such and such. 3 lakh is the price bid document, and period of completion is 7 days. And, my lord, thereafter, according to the report, page 60, and thereafter, my lord, the essential criteria I should, my lord, press before your lordship. This eligibility criteria of the participation in tender. The applicant in the same name and style as prime contractor should have successfully completed at least one contract of the similar nature, at least 40% value of the proposed contract within last 3 years. So, my lord, according to their report, page 60 to 83 is the credential of the of the respondent number 8. Construction of community hall, but page 60, my lord. Construction of community hall of the writ petition. Tender amount is 2 lakh, but this is not the water ATM. Second, 61. Construction of Jamabads from Thailand of Madan Sheikh to these are the, my lord, these are not the water ATM. Then, my lord, secondly, my lord, the construction of pay and use community toilet.
Kindly indicate the page number.
My lord, that is 62, 61, 62, 63, my lord. Cement concrete road. Construction of the concrete road from such and such. Then, my lord, this is a scheme of finance commission such and such expenditure, but this is not even water treatment. 64 up to 80. কত বলেছে? 83. None of the credential will match with the NIT. Page 60 to 83, as their report, it is an admitted fact, but none of the document match with the technical qualification of the participant. Being the respondent 8 declared allegedly a successful bidder. কত বলবি আমাদেরটা?
What is 68? 68.
68. My lord, this is not legible. This is Hasandaga Motiyar Kali. কি আছে এটা? Oh, my lord, this is as because 68 is not legible, 69 is the legible copy. Construction of CC irrigation drain.
These two are separate, sir.
Two are
What
separate.
is separate? What are you
My lord,
submitting? One is of 10th of 2022, another is of 2024. How come 68 and 69 the same document?
69, my respectful submission before this honorable court is that this is not pertaining to the water ATM construction, my lord. But here, my lord, NIT speaks that the construction that is at page 14, where the NIT eligibility criteria is the 40% of the water ATM construction, 40% of the amount about the water ATM construction.
Okay.
And in their report, they have not disclosed the technical qualification of the particular respondent number 8.
Paragraph 7. May I, my lord?
This year,
I have not
that is-
finished. My lord, I am categorically referring 108 of my writ petition. This is in favor of the writ petitioner. This is the payment certificate. Water ATM, Faridpur, Shiptala, and this is the, my lord, the payment certificate. So the petitioner was duly technically qualified. And my lord, again, my lord, I am coming to the page 14 of my writ petition. My lord, got the page 14, my lord. This is eligibility criteria, column 1. Applicant in the same name and style should have successfully completed at least one contract of similar nature. So none of the, my lord, page 60 to 83, none of the document has been given in this writ petition showing that the respondent 8 have completed the similar nature of work having the 40% value of the proposed. And my lord, the period of completion is 7 days. And my lord, terms and condition below that parties eligibility criteria, terms and condition, I am referring the successful contractor. My lord, kindly come to the paragraph 6 under the terms and conditions of in the same page.
Yes.
The successful contractor must complete the work within the time specified for completion. No extension of the time will be given in favor will be cancelled without assigning the reason therefore. the undersigned may also proceed to get the balance work completed by any other means, including through other contractor. Excess expenditure, if any, due to such step should be recoverable from the unpaid bills of the security deposit of the tenderer. So, from their Milord, now from their report, it will be appearing that the work order was issued in favor of the respondent number 8. My lord, kindly come to the report once again, internal page of the report 4, paragraph 7. The NIT dated 7th March 2025 clearly speaks about the eligibility criteria. As per the eligibility, both the petitioner respondent number 8 qualified. Petitioner did not participate. The table bid work order issued in favor of the respondent number 8. The writ petition, in the writ petition, page 60 to 80, which I have already shown your lordship, the document regarding the credential of the respondent number 8. The case of the petitioner is that the particular 60 to 83 of the document which I have annexed to my writ petition is none of those documents is relevant for the particular NIT. The petitioner is trying to delay the process of filing the writ petition. By filing the writ petition, if his intention were at all bona fide, he should have filed the writ petition long before, at least during opening the technical bid or before issuing the work order. He came before this honorable court on 17th June 2025, which shows his intention. Work is almost completed. Petitioner is not allowing the respondent number 8 to continue the work. This particular statement shows that the installation has not yet been completed. Now, my lord, the petitioner came before this honorable court with tainted hands and he did not disclose the notice which has been sent him for table bid. My lord, in my reply, I have dealt this paragraph. The table bid is nothing because this table bid is required to be on the basis of the notification issued by the state of West Bengal, being the respondent number 1 of my writ petition. Because because these are all this, the tender document, the purchase is being issued upon the purchase policy of the government of West Bengal under the West Bengal financial rules. So table bid should have been defined under the West Bengal financial rules. I categorically submit this particular word table bid has not been defined in the West Bengal financial rules. None of the notification there are made thereafter.
So what is table bid?
No table bid.
Table bid is, my lord,
Which-
suppose if
You understand what is table bid? Let him clarify.
If-
Milord,
We'll come back to you.
in
Yes.
financial bid, if two L1 and L2, if the financial bid is same, then a bid is called amongst themselves. The whoever gives the more like, he will get the contract or work order. That is called table bid.
Yes.
Yes, but that is not the table bid, my lord. Table bid is there is a particular notification that upon there is a notification and where the successful bidder will offer some less of the price quoted by the successful bidder. If there is a tie, my case is this, my lord, there is no question of tie because the respondent number 8 was designated as an L1 candidate with a malafide intention without having the proper technical qualification as which has been stated in the particular NIT. This is my first contention, which necessitated the judicial review. Now, my lord, he did not say anything about his presence on ATO. I enclosing the document for kind perusal, copy of the requesting the petition. My lord, I am not denying this. They have been given this and this, and copy of the relevant pages of the resolution. I said this resolution at this sham document, my lord, mere a paperwork and work order issued in favor of the respondent number 8. I say the respondent number 8 could still till date. This is their admitted fact. Pursuant to the NIT, the entire water ATM is required to be completed within 7 days. So, my lord, they kindly come to the page 11 of their report. installation of building of the work order and the date of issuance of the work order was 8th April 2025. So this is about to be completed before Poila Boishak of 2025. Now, Milord, we are after the Milord Diwali. Water ATM has not been run. So, Milord, this is the water ATM near the Hanuman Mandir. Whatever it may be, the case is that, Milord, whether the particular authority pursuant to this notification and the Milord this terms and condition can made any variance. My respectful submission before your lordship is that the authority neither have any power nor have any other than without issuing the notice can make any variance of the particular clauses on their sweet will. This is my first submission, respectful submission, and Milord thereafter
extend করে দিয়েছে 30 days
ওর দরকার নেই তো 30 days extend করেছে by the even if Milord it was stated that 30 days time has been granted, that will be starting from 8th April to Milord, that means it was expired on 7th May. Still, Milord, it is the report which on the made on 15th September that work has not yet been completed. Even, Milord, in this report they have not made very much clear that why the work, how far the work has been made completed. My respectful submission before your lordship is this: the work has not yet been started again, Milord. If the work something has been started, they have given the photographs and all. And in spite of the service upon the respondent number 8 is not appearing, Milord. And even from this report, from the particular affidavit which has been made before your lordship, it is apparent from the particular deposition of the report that I am the respondent number 8.
The typographical error I just submitted.
There is a practice of corruption in the panchayat which is revealing from the report. And now, Milord, I am relying on the Tata Cellular versus Union of India. And all these points I have already taken in my affidavit of exception. This is the three-bench judgment, Milord.
Paragraph.
Milord, I'm coming to the paragraph. Milord, paragraph 77. Upon going through the different, Milord, I am giving the Milord, paragraph 77. The duty of the court is to confine itself to the question of legality. It is concerned should be whether the decision-making authority exceeds its power, committing an error of law, committed the breach of rules of natural justice, reached a decision without no reasonable tribunal should have reached, or abused its power. My first submission is that, Milord, relying on this judgment, Milord, on the paragraph 77. So, Milord, first, the decision-making authority exceeded its powers, admitting the particular respondent number 8 neither have the technical qualification. The question of financial qualification could not have been arrived as because it is apparent from the NIT, this is a two-stage bidding. So, the particular respondent number 8 neither have the technical qualification. Question of financial qualification could not and does not arise. I am not troubled with Milord going through all these Milord judgments recorded in this judgment, Milord. I'm coming to the relevant portion. Now, my lord, 94 of the same judgment. The principle deducible from the above, the modern trend point of the judicial restraint is in administrative action. The court does not sit as a court of appeal but merely reviews the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If the review of the administration is permitted, it will be substitution its own decision without necessary expertise, which itself may be fallible. The terms of the invitation of tender cannot be open to judicial scrutiny. I have not challenged the terms of the NIT. Then, my lord, clause 5 of the particular paragraph 94, that government must have freedom of contract. In other words, the fair play in the joints is necessary for concomitant for all administrative body functioning in an administrative sphere or quasi-administrative sphere. However, decision must only be tested by the application of Wednesbury principle of reasonableness. So, my lord, there is a question of reasonability which is required to be tested. That why the particular respondent number 8, without being technically qualified, was allowed to participate in the particular tender proceedings, and my lord, his technical bid was allowed, and thereafter, my lord, he was awarded the contract. Next, my lord, I am submitting, I am relying on the, my lord, Jagadish Mondal versus State of Odisha and another. My lord, this is a single copy. I'll just reading over the particular paragraph handed over before your lordship. Reported in 2007, volume 14 SCC, page 517.
Volume?
My lord, this is citation is 2007, volume 14 SCC, page 517. Relying on the, my lord, paragraph 22, judicial review of administrative action is intended to prevent the arbitrariness, irrationality, unreasonableness, bias, and malafidis. Its purpose is to check whether the choice or decision is made lawfully and not to check whether the choice or decision is sound. When the power of judicial review is invoked in matters relating to tender or award of contract, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contract are essentially commercial function. Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and is in public interest, the court will not, in exercise of the power of judicial review, interfere even if a procedural aberration or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect the private interest at the cost of the public interest or to decide the contractual dispute. The tender or contractor with a grievance can always seek damage a civil court in a civil court. Attempt of unsuccessful tenderers with imaginary grievance wounded the price and business rivalry to make such and such. Therefore, a court interfering in the tender of a contractual matters in exercise of the power of judicial should pose to itself the following question: whether the process adopted or decision made by the authority is malafide or intended to favor someone. Here is my case, my lord. Whether the process adopted or decision made is so arbitrary and irrational that court can say the decision is such that no reasonable authority acting reasonably in accordance with the relevant law could have reached. My lord, this is the judgment, my lord, and this is the relevant paragraph. My lord, the same principle, again, my lord, reiterated.
Yes.
My lord, and next, I am relying on the my lord, Subodh Kumar Singh Rathor versus Chief Executive Officer and other respondent, my lord, that is Kolkata Municipality, reported in 2024 SCC Online SC 1682.
2024. Which paragraph? Paragraph.
Lord, here, the when this judicial review can be, my lord, invoked, that is from the paragraph 55. Huh. Scope of judicial review in a matter of contractual disputes, my lord. That is one, Roman 1. The court held that earlier position all these rights against the actions, my lord. It starts from then 2, my lord, exercise of the writ jurisdiction in dispute at the stage prior to the award of contract, and after, my lord, 3 is exercise of the after contract comes into existence. So, my lord, here it is. My case is here. Exercise of the writ jurisdiction after the contract comes into existence. I am challenging the particular engagement of the respondent number 8 when, as because the contract is itself a malafide. The court held even after the contract comes into existence, an action may lie by way of writ petition either number 1, obviate and arbitrary or unreasonableness action on the part of the state, or 2, to call upon it to honor its obligation unless there is a serious or genuine dispute as regard the liability of the state from honoring such obligation. Existence of an alternative remedy or disputed question of fact may be a ground not to entertain the parties of the writ petition as long as it is not being used as a smoke screen to defeat genuine claims of the public law remedy. After the contract is entered, there can be a variety of circumstances, my lord. Then this is the, my lord, the entered. These are the grounds, my lord, which has been stated when this petition can be entertained, my lord. And my case is that, my lord, it is apparent from the record and the, my lord, from the NIT. NIT sought the qualification of different is qualification of the bidder to a certain extent. The bidder which has been bidder is qualified. Bidder is being qualified in other technicalities, but not but he is not qualified to participate in the particular tender following the provision of the NIT. And, my lord, thereafter, my lord, his technical bid was allowed and the work order was issued. And table bid which has been referred, the particular authority, Gram Panchayat, is required to show that a notification of table bid has been issued following the provision of West Bengal Financial Rule 47, that such table bid is required to be considered at the case of time. But the report did not disclose no such of, my lord, it is a mere outside of the negotiation. outside the purview of the particular NIT, my lord. It is a mere negotiation. There is nothing, my lord. The entire decision making process is illegal and, my lord, vitiated with fraud, my lord. Required to be set aside.
You have been served with a notice to participate in table bid.
Yes, I was served, but I say this participation of the table bid is required to be required to be within the purchase policy of the government of West Bengal and within the financial rules. Neither it is disclosed in the report that it was this particular table bid is being made following the provision of the West Bengal financial rule under the different subclauses of the rule 47. Nor it was said that this particular table bid is being made. Table bid is called for following the particular notification issued by the respondent number 1 being the state of West Bengal. The table bid.
There in the financial rules, it is there. Table bid is there.
No, my lord. Table bid is not there. I can take, my lord, responsibility that table bid is not there. But this another provision is there, but that is not the table bid, my lord.
What is the provision?
My lord, there is a notification that there is a notification that bid amount must be more than 10 lakhs and above.
So if there is a tie, what is the provision?
Provision is that all the bidders are required to be called for and they have to given a chance saying that how much less they can give. But that is not the table bid.
Why all the bidders has to be
All
called?
the bidders means the bidders who are financially qualified.
So they have called you.
Milord, that is not the table bid. Table bid is something else, Milord. Table bid, because they have to cite the notification on the basis of that is not the table bid. Means that there is a tender selection.
The copy of the letter that they have sent you to participate in table bid.
But first of all, Milord,
where is that copy of that letter?
That is in the
Page 6, my lord.
Page 6 of the
Of my
report. I am not denying to that. I said the respondent number 8 did not have and does not have
page
this
একটা page দিন Yes, that's all.
Yes, that's all.
Yeah, my lord.
Yes.
My lord, firstly, let us go through the timeline, my lord. Kindly comes to page number 15 once. 15 number 8 petition.
Page number
15. Date and time schedule. One five, my lord.
Yes.
Second page of the NIT. A particular chart is date and time schedule is given. Kindly see, my lord. Date of uploading of NIT and other documents, 13th March 2025. Document download, sale start date, 13/3 something. Bid submission date, 13/3/25. Bid submission closing date, 26/3/25. Date and type of opening up technical bid, 28/3/25. And original paper of any document such as credential, GST attendance will be shown on. This is the important, my lord. That is 28/3/2025. My first limb of submission is on 28/3/2025. All parties participating in the tender, they could see each other's document. They have gone through the documents. They have seen each other's documents. I'm asking the question to myself, if I had any problem with anyone's technical qualification, I could have challenged that. I did not. I waited for the opening of the financial bid. In the financial bid, what happened, my lord? Subsequently, so for my first limb of submission is technical bid. After seeing the document, no challenge was made by the petitioner. My second limb of argument is, my lord, financial bid was opened and it was found that the both bidders, that the petitioner and the respondent number 8 are the L1 bidders. After that, what was done, my lord, kindly comes to page number 6 of my report. Page number 6, a notice of my report, my lord.
Yes.
On 3rd April 2025, a notice was issued to the L1 bidders stating that the quotation is same. You come and join for a table bid. There it will be decided who is going to get the order. And subsequently, this particular order, this particular notice was not challenged. Even if, my lord, if your lordship sees the prayer after this two, my lord, kindly sees the prayer. Starts from page 10, prayer of the writ petition. What are the prayers, my lord? First, prayer A, issue a writ and or in the nature of mandamus commanding the respondent and each of them to act in accordance with law and to assign reason as to why the work order issued in such and such under memo such and number shall not be terminated. Second prayer is issue a writ in the nature of mandamus commanding respondent and each of them in accordance with law and to assign reason as to why work order in notice inviting tender such and such under memo number should not be issued in favor of the petitioner. Third, issue a writ in the nature of, this is important, my lord, certiorari calling on respondent number 127 to certify and transmit record to the honorable court upon consideration of the same and pass appropriate order so that as to do conscionable justice to the petitioner. My certiorari prayer is there. I'm asking the question to myself whether he has asked setting aside of the technical bit, whether he has asked for setting aside my learned friend harped upon this particular order, that page number 6 table bit, whether a single line is there or not. I'm asking the question to myself. In the writ petitioner, he has annexed all the documents, but he has suppressed a material fact, and for suppression of the material fact, the writ should be dismissed with cost. He did not disclose about this technical particular notice. He did not disclose about the resolution. In the resolution, he was present, but he did not participate. Kindly comes to page number 7 of my report.
After the recess, we'll continue. After the recess, we'll continue.
After the recess, yes. I have shown the timeline. I have stated that after opening of the technical bid, he had time. He didn't come before the court. After the issuing the notice of table tender, he had time. He didn't approach the court. Now NIT is important. My learned friend was showing NIT. NIT is a document. It cannot be read as per their own terms. It should be read as a whole. The doctrine of approbate and reprobate. Why I am saying so, my lord, kindly comes to page number 16 of the writ. The writ petition is not mentally available. Why, my lord? 16. 16 point number 9. I am placing, my lord. In case if there be any objection, complaint regarding non-eligibility in the technical bid evaluation, only intending bidders or authorized person on behalf of the bidders may lodge objection complaint along with specific authentic document in support of their objection complaint as proof to the notice inviting authority or chairman, tender evaluation committee within 48 hours of the publication of the time uploading document in the web portal and all. NIT clearly says if any objection, which my learned friend is harping so much about technical bid before your lordship now, the time was 28/3/2025 and 40 hours from 28/3/2025. This was the time by which at best this point could have been raised. He chose to remain silent. This document is binding upon the parties. My learned friend rightly showed a judgment, Tata Cellular. Tata Cellular points out the limitation of the court. And Tata Cellular says that where court can interfere and court cannot interfere. This is a contractual terms. NIT is binding upon the parties. My learned friend chose not to take any steps in terms of section 9, rule 9 of this NIT. My first point, my lord. This is my second point. My third point would be, my lord, my first point was time schedule. He didn't approach in time. My second point is NIT, 48 hours time. That lapsed long ago, no steps taken. My third point, my lord, I was referring to the prayers from page 11. A and B is mandamus for setting aside and second to granting the award to him. C is important. Issue a writ in the nature of certiorari calling upon respondent number such and such to certify and to transmit record to this honorable court may upon considered of the same and pass appropriate order so that conscionable justice to the petitioner. I am asking the question to myself. So prayer of certiorari is there, but where is the prayer of setting aside? I am asking the question to myself. He didn't ask for set aside of the first document, that is table bid, the notice of table bid. He doesn't ask anything about the setting aside of the table bid procedure. Admittedly, both L1 same. Admittedly, notice was given to him. Admittedly, he went, but he didn't participate. And after that, only one bidder left. So as per rule, it was given. There is no illegality in this. Now, my lord.
He, after receipt of the notice of table bid, he appeared before the authority.
Yes, my lord. He was present, but he didn't participate in the table bid.
You have annexed this document?
My lord. My resolution kindly comes to page 7.
Here.
7, Adhokal Sabha Sabapati such and such, then the name L1, L1, L2, L2, L3, L4. যেহেতু মোস্তাকিম সাহেব এবং খোকন ঘোষ দুজনেই L1, সেহেতু অধ্যভার সভায় টেবিল বিডের আয়োজন করা হয়েছে। উক্ত বিডের সর্বনিম্ন দর প্রদানকারীকে L1 বলে স্বীকৃতি দেওয়া হবে এবং সেই বিষয়ে মোস্তাকিম শেখ রেট 20% L1, নেক্সট পেজ, মধ্যে শুধুমাত্র মোস্তাকিম শেখ টেবিল টেন্ডারে অংশগ্রহণ করেছেন এবং খোকন ঘোষ এই সভায় অংশগ্রহণ করেছেন কিন্তু টেবিল বিডে অংশগ্রহণ করেননি। He didn't participate in the table bid. Now, my lord, the issue of this resolution is of 8/4/2025. Now, my lord, kindly sees the date of filing of this writ petition. That is 17 June 2025. I'm asking the question to myself whether a single line averment is there in the writ petition to this to justify that delay, to justify the reason for not disclosing the document notice which was sent to him. The petitioner came before you, this honorable court, with a tainted hand. And an attempt was made to suppress the material fact and mislead this honorable court. The writ petition should be dismissed with huge cost for wasting time of this honorable court. And moreover, my lord, 40% work has been completed. Rest could not be completed only for the reason the present petitioner, being politically active person in the locality, he is creating chaos. He is creating chaos. He is not allowing the L1 bidder to complete the work. Well, that's all, my lord. Grateful.
May I be given liberty to reply to the submission made by the respondent, my lord? Only I shall,
Time has been given to you.
my lord, I shall cite only one document, that the
Well,
resolution dated,
document in reply, my lord, I never heard of.
What document you sir?
my lord, reply dated, resolution dated 8/4/2024 was the resolution date, and and it was challenged by the representation which is annexed at the page 114 of the writ petition, and the representation was made on 9/4/2024 আমি শ্রী খোকন ঘোষ, আমি কালীগঞ্জ ব্লকের ফরিদপুর গ্রাম পঞ্চায়েতের একজন ঠিকাদার। গত 8/4/2025 তারিখে ফরিদপুর গ্রাম পঞ্চায়েতে প্রধান টেন্ডার বিডের জন্য আমাকে আবেদন জানান সাচ এন্ড সাচ। উক্ত টেন্ডারে আমরা আমরা কয়েকজন ঠিকাদার দরপত্রে অংশগ্রহণ করি। আমরা প্রতিদ্বন্দ্বী ঠিকাদার মুস্তাকিম ঘোষ শেখ মহাশয়ের কাছে উপলব্ধ ক্রেডেনশিয়াল পত্র না থাকা সত্ত্বেও মাননীয় প্রধান মুস্তাকিম শেখকে বিডের অনুমতি দেন। এমত অবস্থায় আমি খোকন ঘোষ ফরিদপুর গ্রাম পঞ্চায়েতের প্রধানের কাছে উক্ত টেন্ডারের অভিযোগ জানাতে গেলে আমার অভিযোগপত্র নিতে অস্বীকার করে। এটা বিডিওকে দিস হ্যাজ বিন সেন্ট টু বিডিও, ব্লক ডেভেলপমেন্ট অফিসার।
Okay.
Yes, that's all.
Report in the form of affidavit filed by respondent number 7 is taken on record, copy served. Exception to the aforesaid, next para, exception to the aforesaid report filed by the petitioner is also taken on record. By the present writ petition, the petitioner seeks for setting aside of the work order issued in favor of the respondent number 8 pertaining to notice inviting e-tender number WB NZP WB/NZP/KLG Faridpurer Farid NIET/15/2024/25 24/25 under memo number 518 Farid দেখে নেবেন তো 7th মার্চের একটা মেমো নাম্বার আছে। The petitioner the petitioner contains that he participated in the notice inviting e-tender, aforesaid notice inviting e-tender. The petitioner was selected in the technical bid. Thereafter, he was also declared as L1 bidder along with the respondent number. How many persons were selected in technical bid?
That is, my lord, that is also.
4, I guess, my lord.
No, not 4, my lord.
My resolution is there, my lord.
My lord, that is page 103, my lord.
Tell me how many persons were in technical
Six,
bid?
six persons were
Six.
selected in the
Six. Petitioner along with 5 others were selected in the technical bid. Thereafter, in the financial bid, the petitioner and respond number 8 was declared as L1 bidder. The respondent number 8 did not have the technical did not respond number 8 did not have the technical qualification as required under the NIT. But he was allowed to participate in the table bid, and arbitrarily work order has been issued to respond number 8 in contravention of the clauses of the aforesaid NIT. Hence this writ petition. Well, Mr. So-and-so learned advocate appearing for the petitioner submits that the respondent number 8 as per the NIT was supposed to submit documents showing that he has completed at least one contract of similar nature of work, at least 40% of value of the proposed contract within the last 3 years. The documents annexed to the writ petition from page 60 to 83 would not show that the respond number 8 had completed any similar nature of work. Therefore, the acceptance of the technical bid of respond number 8 is palpably illegal and bad in law, since it is made in contravention of the aforesaid NIT. The authority concerned ought not to have accepted the technical bid and allowed the technical bid of respond number 8 and allowed him for participating in the financial bid. Thus, the work order issued in favor of respond number 8 is arbitrary and should be set aside. Buttress his contention ওইটা করুন দাঁড়ান কেটে দিন, একটু বাট্রেসিং অনেক কেটে দিন। The duty of the court is to consider the question of legality of the action of the authority concerned and find out whether there is any breach of the rules of natural justice and abuse of powers conferred upon the authority. Buttress his contention, he relies on the decision of following decisions of Honorable Supreme Court. 1. Tata Cellular, 1994, Volume 6, SCC 651. 2007, Volume 14, SCC 517. 2024 SCC Online SC 1682. 2000 এটা আলাদা বলে দিচ্ছি 2024 2024টা আলাদাভাবে বলছি। He further submits that the writ is maintainable when there is a arbitrary or unreasonable action on the part of the authority concerned, and such jurisdiction can be exercised after the contract comes into existence. Now, 2024 SCC Online, in support of his contention, it relies on the decision of Honorable Supreme Court reported in 2024 SCC Online SC 1682. In light of his aforesaid submissions, he seeks for setting aside of the work order issued in favor of respondent number 8. In reply to the aforesaid contention, Mr. Turunjyoti Tiwari, learned advocate, appearing for respondent number 7, Pradhan Faridpur Gram Panchayat, submits that the original documents as relied by the bidders were uploaded in the official website of the authority concerned on 28 March 2025. Therefore, therefore, the petitioner was well aware of the documents furnished by respondent number 8 on such date, but he chose not to challenge the same immediate thereafter. Clause 9 of the NIT clearly stipulates that the bidder can raise objection or complaint regarding non-eligibility in technical bid evaluation within a period of 48 hours from the publication time, that is uploading time in web portal. Such opportunity has not been availed by the petitioner. The petitioner was notified regarding the table bid. Although he appeared before the authority concerned, but refused to participate in the table bid. In such circumstances, the authority concerned chose respondent number 8 as the L1 bidder. The petitioner has filed the writ petition in the month of June 2025. There is no averment in the writ petition regarding the delay in raising the issues. He informs the court that respondent number 8 has already completed 40% of the work allotted to him. He seeks for dismissal of the, on such score, he seeks for dismissal of the writ petition. Oh, I had gone. The petitioner has also suppressed material facts in not disclosing the notice sent to him for participating in table bid. Upon hearing the learned advocates for the respective parties, the only issue which falls for consideration before this court as to whether the work order issued in favor of respondent number 8 by the authority concerned is legal and sustainable. Admittedly, the petitioner and respondent number 8 and others participated in notice inviting e-tender being number such and such. The petitioner and thereafter work order has been issued in favor of respondent number 8 as L1 bidder. The petitioner has challenged the issuance of work order in favor of respondent number 8 on the sole ground that the respondent number 8 has not successfully completed at least one contract of similar nature of work, at least 40% of value of the proposed contract within the last 3 years. The committee, this has been decided by a committee. Which committee is this? Ortho Porikalpana, some committee is
Yes,
there.
Manoj.
Where is the copy of the technical bid having been allowed?
Not problem.
The
Which body, Manoj?
technical bid of respondent number 8. Sorry. The original documents of the bidder was uploaded on 28 March 2025, meaning thereby that the petitioner had the knowledge of the original documents which were relied upon by respondent number 8. Sir, when was the technical bid accepted?
28 March.
On that day itself.
That is.
And the technical
29th March.
29 March.
29th March.
29th March
The
2025.
technical bid of the petitioner as well as respondent number 8 and 4 others were accepted by the authority concerned on 29th March 2025. The petitioner did not challenge the acceptance of the technical deed upon such acceptance. Clause 9 of the NIT clearly stipulates, in case if there be any objection complaint regarding non-eligibility in technical bid evaluation, only intending bidders or authorized persons on behalf of the bidders may lodge objection/complaint along with specific authentic documents in support of their objection complaint as a proof to the notice inviting authority or chairman tender evaluation committee within 48 hours from publication time, uploading time in web portal of the technical bid evaluation. And beyond that time schedule, no objection complaint will be entertained. Undisputedly, the petitioner did not lodge any objection or complaint regarding the acceptance of technical bid of respond number 8. There is also no averment as to not availing of such opportunity as provided in clause 9 of the NIT. Therefore, the complaint not being lodged in terms of NIT, the petitioner has filed the writ petition at a related stage when work order was issued after technical bid was accepted, technical bid of respond number 8 was accepted. Para 96 of Tata Cellular. 94, sorry, 94. The decisions in Tata Cellular as well as the decisions in Jagdish Mandal Sutra, which has also considered the decision in Tata Cellular, clearly lays down that the court does not sit in appeal but merely reviews the manner in which the decision was made. Thus, in light of the above, since the petitioner who had the opportunity as per the NIT to lodge complaint regarding acceptance of technical bid of respond number 8 did not avail of the same cannot be interdicted by way of a writ petition at this stage when the work 40% work of the particular job has been completed as informed by the learned advocate for respondent number 7 by respondent number 8. Accordingly, the writ petition stands dismissed.
Grateful, Lord.
It didn't. Judgment is fine. Affidavit is served.
I've gone through the affidavit of service. My lord, everyone has been served except Jela Porishad. Jela Porishad, my lord, endorsement is there that no such, maybe there may be insufficient data. Not kindly see the last track report.
Where is the envelope? You have not received?
No, I have not received.
Chairman.
Item return, no such person in that. Maybe insufficient data.
You will serve appraise?
And Jela Porishad, my lord, I should serve absence. Rest, my lord, kindly see, rest have been served. Subject to correction in this matter, Jela Porishad will not be required because the construction is limited to first floor only, one floor.
You are expunging the name of Jila Parishad.
My lord, may I be permitted to see the liberty, my lord, to expunge the name of Jela Porishad?
What is the contention?
Lord, kindly seize my representation. Private respondents are continuing the construction in Doba and in Pot. Recorded as Doba and Pot. The LR record of rights, my lord, I have annexed. Page 17 onwards. But plot number 64 is Pot and rest are Doba.
What is the extent of construction? Jila Parishad is not a party.
Constructed one storied, my lord, one storied.
It is not a matter of one story.
One story house, page 21, kindly sees that the has since purchased the abandoned persons without due process of law and also without obtaining any sanction plan from the such and such Gram Panchayat has made Pakka one story house. Page 21, second paragraph, third line. And subsequently, they are also constructing by encroaching the pot, which is recorded as pot, without legally converting the character of land that they are constructing.
Which dark number?
64. Plot number 64, police station Degonga, district. Pot, recorded as pot.
Why the Jila Parishad?
Page 17, record of rights, I have annexed. My prayer is limited to let the Pradhan consider my representation dated 17th of April 2025 and take a decision.
Jila Parishad is not a necessary party?
Jela Porishad, my lord, in this as per this representation, this is one story. জেলা পরিষদ after মানে beyond 2-storied my lord জেলা পরিষদ is required.
Yes. What is your report, sir? What is your submission?
Any direction may kindly be given to BLRO to ascertain. Actually, it is hindering egress and ingress. So
Ultimately, construction at the ports, my lord.
Affidavit of service filed on behalf of the petitioner is taken on record. Learned advocate for the petitioner at the outset submit that the alleged construction is below 6.5 meters. And as such, the chairman Jila Parishad is not a necessary. Respond number 2. Chairman Jila Parishad, North 24 Parganas is not a necessary party. He seeks for expunging the name of respond number 2. Learned advocate for the state does not raise any objection. Accordingly, name of respond number 2 stands expunged. Here, the chairman Jila Parishad, not even stands expunged. By the present writ petition, the petitioner seeks for demolition of illegal unauthorized construction undertaken by private respondent. Pradhan has been served.
Yes, my lord.
Yes.
Pradhan has been served, my lord. Affidavit of service, my lord. Page 5, my lord.
Private respondent.
Private respondents are also, sir. Page 8 onwards, my lord. Page 8 onwards, 8, 9, 10.
Undertaken by private respondent 7 to 10. Your allegation is again 7 to 10.
7 to 20.
The petitioner contends that he is a resident of village Purbo Chandana, police station Deganga district, North 24 Parganas. The private respondents illegally constructed one-story building without obtaining sanction plan or requisite permission from the competent authority. The Plot number you have not mentioned.
My lord,
You have not mentioned the plot number.
specifically, my lord, plot number has not been mentioned in the petition.
Huh?
Not been mentioned in the petition.
You are the owner.
No, my lord, they are the owner.
Who are the owner?
They are the owner. My lord, it was in my name. Subsequently, they purchased the plot from myself. Now, the name appearing at page 17 is myself and the petitioner, Babar Ali Mundul. They purchased the plot from myself. It is their plot.
You have no interest over the property.
My lord,
How you are? Huh? Your obstruction, you are adjoining neighbor.
yes,
You are adjoining.
my lord.
Where have you stated?
My lord, kindly sees, my lord, page paragraph 4. Measured 15 feet in wide, but due to the unlawful encroachment, it has now been reduced to 6 feet, severely obstructing the petitioner's right to free ingress and egress.
64 does not stand in your name. Babar 64.
64 is recorded as spot.
This stands in your name.
64, my lord, does not stand in my name, but 64 is recorded as spot. But unless and until the classification is changed, my lord, whether they can construct over the plot or not, my lord, kindly sees.
You say that they have encroached upon your private land.
But the plot is 15 feet in wide. That is common pathway.
You say that the petitioner's private land has been encroached by the private respondents. And again, you are submitting that
Plot
it does not stand in your name. If it does not stand in your name, then how come they are encroaching in your property?
Measured due to unlawful encroachment. The plot has been encroached by their construction, due to the fact that my ingress and egress has been blocked.
No, what you are writing over here?
Kindly
The
see,
private respondents, emboldened by political patronage, have further encroached upon the petitioner's private land, specifically package classified as POT.
Then the plot is in
Then
my
you
name.
say that POT does not stand in your name. Then how come
No,
there is
my lord.
encroachment?
I should be corrected, my lord. I beg for your unconditional apology, my lord. What should be in my name, my lord?
And if it is in your name, then where are the documents?
My lord, page 17.
Then
Page
what
17 is in my name.
What
That
is
is plot.
19? What is 19 then?
19, my lord, is their plot. That is separate plot numbers. Page 17 is
Please
plot.
go through the record and then please come to Dag number 64. This
Yes.
is Dag number 64.
Is in the name of Baburali Mondo.
Koi Monwara Begum. Monwara Begum 19. Monwara Begum is the purchaser.
No, Monwara Begum is my lord mother. Sister, my lord, Pita Bishu Mondo. My kindly says the name of father, Bishu Mondo, and my father's name is also Bishu Mondo. Page 17 and page 19, my kindly says.
Might be.
They have not mutated till date with regard to their plot. But 64
What is
stands in my name.
17 and what is 19? Tell me. 17 is
17 is spot. 64.
petitioner. 19 again is of the
19 is Doba. Some portion is Doba and
64.
some portion of 64 is also there. That is the common pathway. Some portion is in my name. Some portions I have transferred in their name. That is a common pathway recorded as spot.
In name of the brother and the sister.
Name of the brothers and sisters, they have not mutated, my lord. That is why, my lord, the name of my brothers and sisters are appearing.
কি বললাম? And by dint of such construction have encroached upon petitioner's private land, which is classified as spot. Thereby obstructing the petitioner's right to free ingress and egress. The construction has been undertaken by the private respondents over which plot they have undertaken?
64, plot number 64.
Not over,
My lord, in my representation, my lord, it is stated.
not over 60, 61.
Now, my lord, with regard to the raised plot, they have already, my lord, constructed one-story house. That I have stated in page 21, paragraph, second paragraph. And now, my lord, with regard to 64, they are continuing construction. Sixth paragraph. Lastly, on 15th of April 2025,
बोलो over 62 and 63, which is classified as Doba. And further, such construction has extended over plot number 64. Obstructing the ingress and egress of the petitioner. You should have mentioned the plot numbers in your writ petition.
my lord, should have been mentioned.
Paragraph 3, you say that this has been erected on a plot of land classified as Doba.
That should have been mentioned, my lord.
Now, 62 and 63 has been transferred in favor of the private respondents. 3 shatak, 3 shatak, 6 shataks, which is a Doba. Right? Excellent. The petitioner made representation before the concerned local Gram Panchayat as well as other authorities for redressal of the grievance. However, no steps have been taken. Hence, this writ petition. Mr. So and so, Parakuri, learned advocate for the petitioner, seeks that the matter be relegated to the Pradhan of local Gram Panchayat to cause inquiry and consider the representation of the petitioner. Learned advocate for the Mr. So and so, learned advocate appearing for the state, also submits that the matter be sent to the Pradhan of local Gram Panchayat to consider the representation of the petitioner. Despite service, none appears on behalf of the private respondent, the Pradhan, respond number 4. Pradhan, Beda Chapa number 1, Gram Panchayat. And private respond number 7 to 10. Same according within a period of 3 months from date of communication of this. He will cause an inquiry by effecting notice upon the parties.
My lord, I'm grateful. Grateful.
Link. ठीक. Thank you. None appears on behalf of the petitioner, nor any accommodation has been sought for. For ends of justice, the matter is adjourned. List this matter. কোনোদিন পরে. After 2 weeks, under the same heading.
Twelve, madam. I am for the petitioner.
I'm for the state, my lord.
Will be appearing for the state.
State.
That is good. But this is evidence service. The matter relates to my lord filing the report. Unauthorized construction, my lord. And this matter relates to illegal and unauthorized construction by the private respondents. Well, only one arrested is here. That is page 12.
Wait. All the private
Written in Bengali, my lord.
respondents.
May I read out, my lord?
Deliver.
Everybody served.
প্রধান সার্ভিস upon প্রধান
প্রধানকে সার্ভিস করে
14 and 14 and 17.
Respondent number 5. Yes.
14 and 17. Page number 14 and 17. This consignment is sent to whom? To দিন তো.
হাতিয়ার প্রধানকে দেওয়া হয়েছে প্রধান প্রধানটা দেওয়া প্রধানকে দেওয়া হয়েছে এইটা প্রধান কথা
Check the service and file a fresh affidavit of service whether it has been served upon the Pradhan and respond number 9.
in this petition sir প্রধান one second is
Not 1 second. If it is served, then file a fresh affidavit of service disclosing, give the postal receipt.
Yes.
14 and 17, the postal receipt has not been given. 5 and 9, I am not finding it whether it is served or not. If it is not served, we'll decide, then pass a direction. Yes.
The petitioner already claimed page 19 million of land which has been distributed among the family members and only on 3 shotaks land already she is holding.
Petition.
But petitioner, he stated in the petition, but no documents have been annexed in the petition that she is holding any piece of land.
Okay.
And also, her husband already sold the property to the respondent number 10. In the documents already I have annexed, in the report already have annexed. Different thing. There is sold, selling of property. I have not come before your lords. No, already I have come here, lordship, regarding the illegal and unauthorized construction. He has stated that this 3 decimals landed property out of 6 are fraudulently occupied by the private respondent. He is stating in the petition, who are politically influenced persons for that locality illegally constructed building without having any sanction plan over the state plot of land which is exclusively belongs to your petitioner. This is not the belong to the petitioner. Page 19, I have also served. That is, this is not the belong to already served.
Pradhan served.
Yes,
Then what are these two? Where
that
there
is
is
page 19.
Page 14 and 17 does not have postal receipt.
Yes, sir.
This has been sent to whom? Which of the respondents? You have the postal receipt with you? Sir, please find out and file a fresh affidavit of service on the returnable date. I am fixing a date on Wednesday. You file that. In the meantime, give a copy of that report to him. Give a copy to report filed by state, furnished by SI Bosirhat Police Station, dated 26 June 2025, is taken on record. Copy served. Copy given. Learned advocate for the petitioner seeks accommodation to file affidavit of service. Means this matter. When is the 29th. 29th. Find out.
29th of this month.
Do you want November?
29th of October.
29th.
Get your safety. What? Report we kept on record.
You have given a copy?
No, I didn't get that.
Give a copy.
I am on behalf of the petitioner. Lordship, there is a typographical error in page 2, respondent number 3, subdivisional officer, Sirampur. Sirampur replaced Chandonagar. Kindly.
On the prayer of learned advocate for the petitioner, liberty is granted to correct the nomenclature of respondent number 3. Learned advocate for the petitioner, liberty is granted to correct the nomenclature of respondent number 3 from subdivisional officer Sirampur to subdivisional officer Chandonagar. Correct. Affidavit of service, you have to send again to him. The others have been
served.
Affidavit of service filed on behalf of the petitioner is taken on record. state, state serve.
State page 3.
Police, Pradhan. ঠিক, এরকম। নদী,
My lord, matter is related to illegal construction over.
First you serve upon the respondent number 3. কি বললাম? Affidavit service final be record. It is found that service has been effected upon the state respondents as well as respondent number 6 to 13. In view of the change in nomenclature of respondent number 3, comma, petitioner is directed to serve upon respondent number 3, subdivisional officer Chandan Nagar, registered speed post with acknowledgement due and file affidavit of service on the returnable date. This matter 15 din pore after 2 weeks. Under the same heading, 12.
12. My lord, kindly correct in the.
Everybody did correct.
Lordship, I'm for the petitioner. I'm led by Advocate Shobhusai Chatterjee. He is currently engaged in another court. I will assist your Lordship until the leading counsel arrives. Your Lordship, this is a matter pertaining to unauthorized construction. Your Lordship, the petitioner has challenged, the petitioner through his writ petition has challenged the inaction of the state respondents for not complying with the order of demolition passed by SDO. Your Lordship,
I am for the. May I just interrupt once minute? There is an electrical problem. That's why I cannot open the camera. I am for the state cannot kindly direct the video to implement the order of the subdivision officer within a specified time. My lord.
Yes, Lordship. That is my main prayer. Your Lordship, the order of the SDO is annexed in.
Order of the SDO has been challenged before your Lordship by the private respondent. That the writ petition has been dismissed by your Lordship.
This order was challenged.
Yes, Your Lordship.
What
Your
This
Lordship,
order has been challenged before your lordship's court, and your lordship was kind enough to dismiss the writ petition.
Your Lordship, the said order is annexed in page number 51, from page number 51 onwards.
Okay. So what is the grievance in the present writ petition?
Your Lordship, the order of the SDO is not implemented. Your Lordship, since the order of the SDO was challenged before Your Lordship, and Your Lordship dismissed the petition not having any merit, so the order of the SDO becomes revived, and it should be implemented. But the BDO is not implementing the order. Your Lordship, the order of the
What?
SDO is annexed in page number 49, 49 and 50. Your Lordship, in the operative portion of the order, the SDO has ordered. Now, I, in the capacity of SDO, in exercise of the powers conferred,
Page number.
Your Lordship, page number 50 is the operative portion of the order of the SDO. Page number 50. Your Lordship, I'm reading. Now, I, in the capacity of SDO, Kartik subdivision, in exercise of the powers conferred upon me by subsection 5 of 23 of section 23 of the West Bengal Panchayat Amendment Act 2017, do hereby order the respondents, that is Kachuar Ali Mullah and Rashid Ali Mullah, they are the private respondents in my matter, to remove the illegal and unauthorized construction of the building or structure from the land from LR plot number 1497 of Mauza, Ramgopalpur, jail number 29 under Ramgopalpur Gram Panchayat, PS Dholahat, district South Chobis Pargana within 15 days from the receipt of this order at their own cost, failing which the BDO Kakdeep Development Block will take necessary action to remove the said illegal construction of the building / structure after the expiry of the stipulated period of 15 days, and the entire cost of such action will be recovered from the respondents Kachuar Ali Mullah and Rashid Ali Mullah and Yunus Ali Mullah as public demand. As a public demand, the inspector in charge of Dolahat Police Station, Sundarban Police District, is hereby directed to serve the order sheet to all concerned and submit the service return to the office of the undersigned well in advance. Your Lordship, it has been complied with, but the order has not been implemented.
What has been complied and what has not been implemented?
Your Lordship, the demolition has not been done.
But may I assist your lordship? But what happened after the order of the subdivision officer, the BDO went to demolish, but the private respondent challenged the said order before your lordship's court. Then your lordship dismissed the writ petition. Thereafter Durga Puja, Kali Puja, order could not be implemented. Kindly direct the block development officer to implement the order of the subdivision officer within a specified time. Subject to lordship's approval.
Affidavit of service filed by the petitioner is taken on record. All the private respondents have been served.
Yes, Lordship.
Nothing has been annexed to the but where is the track consignment report?
Lordship, that has not been annexed.
You have not seen that it has not been annexed. So how could you say that it has been served?
Your Lordship, the postal receipt is annexed.
The receipt is not that it has been served. You have got the
Your Lordship.
track concern report with you.
No, not right now, Your Lordship.
Learned advocate for the petitioner seeks accommodation to file. It is written করুন. Affidavit of service. You find out the track concern file of
Yes,
affidavit
Lordship.
of service. Friday the next. Mr. Mukherjee, it is adjourning till Friday next.
My lord, on extremely great.
Friday. 31.